Good morning, everyone. Hope everyone's doing well, and we're well into week 2 at this point. So appreciate all the engagement and the discussion from week 1. It was great. I appreciate all the experiences that were shared. That's the thing about healthcare and ethical, legal issues. It's that all of us have either had an experience that may implicate some ethical or legal issues, or we know somebody who has. And many of you, if not all of you, are working in the healthcare industry, so you may see it all the time. But that's certainly something that we all have experiences with and can share. And I appreciate you doing that. So very, very good job on the discussion this week. So starting to grade the assignments. It's gonna, that first week there are 2 written assignments. So it always takes me a little bit longer to do that. So I will do that progressively throughout the week. This is, I think you guys are in chapters 2 and 3 this week. I wanted to discuss a little bit about the legal system and specifically about medical malpractice. So your week 1 assignment involved looking at that case that we're going to be studying, the Itraldi case that we're going to be studying throughout this course. And so I wanted to discuss a little bit, touched on a little bit last week, but wanted to get a little bit deeper into the elements of a medical negligence case to help you with that analysis that you'll be conducting throughout the various assignments in this course. So first, the legal system, and if you have any questions, please feel free to reach out. I know several of you have, and I absolutely encourage that. And I know that kind of the legal jargon, the sort of the legal analysis, that mindset is normally not intuitive, and so it takes some practice, and it takes some getting used to and some studying on how to do that. So if you have any questions, I definitely encourage you to reach out. If you go to page 43 of the text, there's some discussion about the legal system, particularly related to healthcare. And I don't do a lot of litigation. Most of the litigation I do is in the administrative realm. So I do a lot of Medicare, Medicaid reimbursement and audit litigation. That's all on the administrative side. So you don't start out in state court or federal court for those issues. You start out in just the administrative agency courts or some sort of hearing setting, depending on the state, or if it's Medicare or Medicaid, and then work your way through that administrative process. And you may eventually end up in state or federal court on those issues, depending on how long it takes. I've been in state. I've had state boards of board of medicine here. I've been in state board of medicine hearings for physician disciplinary matters. Very sort of different setting where you're presenting to an entire board who will hear a case, and there will be an agency attorney that's presenting the other side, and typically you come to terms or you don't, depending on how egregious the issue is. But that's an interesting experience as well. Licensing issues. Anyway, those are all sort of administrative issues. The only time I've really done state court issues, but back in the early, I'm digressing, but in the early years of my practice, I worked with one attorney who had a long-standing client that financed farm equipment. And so my job as a brand new associate was to go out to these small town courts in western Kansas and basically evict farmers from their enormous combines and farm equipment. So that was tough, but that was an interesting experience. So other than that, that's not healthcare related, but other than that, I don't do too much in the courts, but certainly familiar with it. So if you have any questions, let me know. I wanted to talk, and remember, I just want to reemphasize this throughout the course, and that's there. While there's some overlap, ethical issues, legal issues, ethical components, legal components could be two different issues. And today I want to talk a little bit about the legal side, specifically about medical malpractice. So if you go to page 40 of your text that discusses negligence, and when you medical malpractice, I think there's some discussion in your text about torts. Is a tort, and which could create some form of civil liability, not criminal, but civil liability. There are all kinds of cases that involve negligence, and medical malpractice is just a form of the negligence cause of action. And it has generally the same nuanced four elements that would apply to a negligence case. And so I talked to you a little bit briefly about these four elements last week, but I want to dive into a little bit deeper this week. Here's the thing that's really important. And so as you conduct your analysis in the various assignments throughout this class, it's important not to say, well, clearly the doctor was negligent here because of blah 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 blah, because of X, Y, and Z. And that's not a deep analysis. A deep analysis would say, okay, at issue here is medical malpractice and potential negligence. There are four elements. I think your text refers to them as the 4 Ds: duty, dereliction, and I don't remember. But regardless of what you call them, there are 4 elements. And here's the rule for the first element. Here are the facts. Apply the facts to that rule. Is that element met? Yes or no? Based on your legal analysis and your conclusion. If the answer is yes, okay, we'll go on to the second one, and so on and so on. So you have to attack each individual element, because if the facts do not support any one of those elements, then you do not have a viable negligence or medical malpractice case. So it's important as you conduct these analyses that you attack each element individually. So like the first element, there are 4 elements. I think it's chapter 6. It's discussed a little bit further if you want to read ahead there. But the first one is there's a professional duty owed to the patient. And you'll see as you read in the text, that duty is typically created when the physician-patient relationship is established. Okay. So, and you can read in the text how that's established, but once that's established, there's a presumed duty. So in your analysis, question is, do the facts support that duty exists? In this case, the answer is yes, because the patient, in the Ituraldi case, the answer is yes, because the patient went in for that surgical procedure. So the second element is whether or not the physician or the practitioner met the standard of care. And this is a highly litigated issue in these medical malpractice cases, because the standard of care may differ or may not differ. So that's the issue, that's the essence of the debate of the litigation. For example, in a rural the argument is in a rural, at least for the defendant, in a rural hospital or rural health clinic, critical access hospital out in the middle of nowhere, the defendant would argue that the standard of care is lower because they don't have lower than if the hospital were in some large urban area, because they don't have access to the same equipment, to the same information, to the same sort of expertise that you would have in this larger urban medical center or a hospital. Now, the plaintiff would argue that's hogwash because we all have access to the same information. We all have the internet. We all have resources to to various medical articles and white papers, whatever it may be, that dictates what the standard of care, or teaches what the standard of care is. And so there's no reason why a doctor in Waukene, Kansas would have to practice under a different standard of care than someone in New York City. So that's sort of the debate that goes on between the two sides. Now the third is if there was the third is if there was injury. So the injury, if the physician had a duty. The third is causation. It's early in the morning. The third is causation. So there could have been a duty, there could have been a breach in the standard of care, but did that action of breaching the standard of care or deviating from the standard of care, did that cause the injury? And that's when you get into the debate about pre-existing injuries, or while the doctor breached the standard of care, it didn't cause the actual injury that the plaintiff is claiming, because 15 years ago the patient broke her back and skiing, and that's actually what has caused all the pain. So that's the sort of back and forth. Was there direct causation? Was there proximate causation? Essentially, did the injury cause, or did the act cause the injury that's alleged? And the fourth is damages, or there could be injury, but what's the extent of that injury? What are the damages? And so there's an analysis of what that may be. So those are the four elements. Again, it's important in your analysis to attack each one individually, because if one does not exist, or the facts do not support one, then you don't have a viable medical malpractice claim. We're going to get, I want to discuss a little bit, just, if you've worked in the healthcare industry for any amount of time, you know that the industry is highly regulated, and both at the federal level and the state level. And so we're going to get into things like privacy and HIPAA. We're going to get into things like fraud and abuse, federal fraud and abuse laws related to referrals and ownership interests in medical centers or healthcare entities, and just sort of the business and economics of healthcare. But I would just off the top of my head, I made some notes on the various laws that I deal with, and any healthcare, anyone in the healthcare industry likely deals with at some point, depending on what they do in healthcare. But and so just to give you an idea, and this is just off the top of my head, to give you an idea of the various laws and regulations at play that govern and regulate the healthcare practice. It's pretty amazing when you just sit there and write it down. So like HIPAA, Stark Law, Anti-Kickback Statute, which is a criminal statute we'll talk about later, Medicare conditions for coverage, conditions of participation, the Federal False Claims Act, beneficiary inducement prohibition, civil monetary penalty law, Medicaid rules and regulations, state fraud and abuse laws, insurance regulations, privacy rules, patient abandonment rules, which we'll also talk about a little bit later, state licensure laws, accreditation rules, informed consent laws, Good Samaritan laws, living wills, DNRs, etc., end of life sort of issues. Antitrust laws is a big one. Facility-specific laws, like academic medical centers. There are laws regulating specifically ambulatory surgery centers, SNFs, critical access hospitals, rural health clinics, federally qualified health centers, etc. And then there's FDA laws and regulations. So we're going to briefly talk about clinical research, and throughout this, I can't remember which week it is, but you think of the FDA, the laws and regulations, drugs and medical devices, clinical research. There is just a host of both state and federal regulation that governs what is right and what is wrong in this scenario. Scope of practice issues related to any practitioner that is licensed. So this not just physicians, but also, in fact, maybe even more importantly for nurses, advanced nurse practitioners, PAs. They operate within a specific scope of practice, as you know. And need to continue to need to fit within that and all that they do. And then there's the medical records laws. HIPAA is a federal law, and every state pretty much has its own privacy law that either mirrors or maybe more stringent than HIPAA. But beyond that, there's medical records, custodial laws, record retention laws, and things like that we'll get into. So. Anyways, that's just to give you an idea of just the vast field that is healthcare law and ethics that's out there, and that's I guess that's what keeps me employed. So, again, please reach out if you have any questions. Let's make it a fantastic week. I am around if you need anything, and I will proceed and continue to get that grading done before this coming Sunday. So hope you have a great week, and we'll talk to you later. Bye.